My name is Vincent Ramlochan, and I'm the commercial officer based at the Embassy of the Republic of Trinidad and Tobago in Panama City. Firstly, I just want to thank each and every one of you for taking time from your busy schedules to learn about distributor contracts, intellectual property, product registration, and packaging and labeling requirements. These have been topics of interest from our exporters, and it is my hope that this session this morning will give you clearer understanding of the legal aspects of doing business in Colombia and increase your knowledge and confidence about this dynamic market. I would like to introduce our first two presenters for this morning's session. Firstly, I would like to introduce Mr. Alvaro Rincon, who's the General Director, and Ms. Isabel Santin, who's the Regulatory Affairs Director at SPI Americas, who will share with us the legal essentials for exporting to Colombia. So without any further ado, over to you, Mr. Rincon and Ms. Sanin.
Thank you, Vincent. Hello, everybody. Greetings from Bogota, Colombia. We're very glad to be here with you, thanking the Embassy of Trinidad and Tobago for the opportunity. And we hope that this journey that we're going to start right now will give you insights and open your possibilities to do business in Colombia. In our firm, SPI Americas, we always start this type of webinars and training sessions with a small intro of what we do. We've been around for the past almost 32 years. We're based out of Bogota, Colombia. Adelante. And we have been helping companies doing trademarks, registrations, business contracts, incorporations, not only in Colombia, not only in Latin America and the Caribbean islands, but also globally. What you see here is a summary of or a small number of activities we've performed during the past 31, almost 32 years. These are our practice areas, and we're going to try in this hour that we're going to speak to you guys to address all of them, hopefully in an efficient way, so you would have good information. So we're starting, and as per the request that Vincent made to us, in Colombia, companies can incorporate. If you want information of incorporation here, and we will, Vincent is going to share this presentation. At the end of the day, in Colombia, foreign companies are welcome to invest in Colombia, to incorporate in Colombia, and to open companies in Colombia. Nowadays, in Colombia, there's one type of entity, of company, that is more or less 98% of the new incorporations. That type of company is 98% of new incorporations in our country. Why is it? It's because it's the very most efficient way to do this incorporation. Here, you see the steps to open a company, which are very easily met, number one. Number two, the process, once incorporated, would be very easy to handle, because before this type of companies, you would need to go to the notary public, you would need to legalize documents, you would need to do a certain number of activities that nowadays with this type of company, this type of companies, there's no more need to do. It's only private documents, documents that you simply send to the Chamber of Commerce of Bogota, and you would be good to go. Again, I don't want to go into the details of what you're seeing here, because this is very clear and this is the way it goes. If you decide to open a company in Colombia and you decide, in case you want to work with us, obviously we would provide you with further information. This is something that this would let you know exactly how to address the situation of incorporating in Colombia. Okay? Easy. Vale. Regarding contracts and agreements, number one, the most important thing to do is not only because it has to be duly drafted, we recommend to have written contracts. But first of all, the most important thing is what is it that you're going to do with your local distributor, your local partner. You have to agree on the exactly what is it that is going to happen and with whom are you going to work. What is it that the Colombian part is going to do? What is it that the Trinitarian part is going to do? And to have all of these, if you see all of these items that we have, that we're showing here for you, to address them all. Because you don't want to have situations in the future that somebody would say, I thought that this was not something that I was going to do, or I was expecting that you would do it. You don't want to be in that situation, and that applies for not only for Colombia but in general for any type of country, and even for any type of activities that you're going to perform with somebody else. These items that we show you here and that we have included here would work easily in any type of relationship with any type of business partner, not mattering the type of activity that you're going to perform. Dale. For Colombia, in case you're imagining, oh, I need to do the contract in Spanish. That's the language we speak down here. The answer is not, it is not mandatory. Obviously, in case there's a legal action, a formal official translation would be required at the moment, but not at the beginning. You can address all of your agreements in English. That would be valid. There is nothing that mandates that you should have a Spanish written contract. For the case that there is an issue that needs to be addressed, and this is something, if you go back to the list of items to bear in mind, arbitration is one clause that should be added. Again, not only in Colombia, we strongly recommend that you would have it in each and all of your agreements, because you would need to have a way to solve situations that arise in a business relationship, in a partnership, and so on. Normally, for local activities in Colombia, local companies would prefer to have the arbitration performed here in Colombia before the Chamber of Commerce, for example. That's normal. But it is also normal to have arbitrations taking place in other venues. In our experience, we have contracts with clients that are to be dealt with, the arbitration clause in London, in Miami, in Paris, in Bogota. Now I don't remember, in New York City, and so on. So this is something that is not, again, mandatory, in terms that if you don't have an arbitration clause, that doesn't mean anything, except that in case something arises, that part would be skipped. And there is no mandatory territory to deal with the arbitration. Dale. There's a big, if you recall, the first thing I said, you have to be clear about what is it that you're going to do from Trinidad, and what is it that the Colombian counterpart is going to do. Because there is a very potential complex situation depending on the way you address your agreement. For example, if you're planning to sell to somebody in Colombia your goods, and that person in Colombia is going to mark up and sell on a different price, et cetera, the product you're planning to sell, that's a simple distribution contract. That means that you won't tell them how much money, how to sell it, where to sell it. You're not dealing with any type of, you're not giving them insights of how to do the business. That's a distribution contract. On the contrary, there's a way in contracts of agencies. That means that somebody would represent you locally in Colombia, and that would have a different way to address it. Agencies normally are paid via commission. Distributors, they're not paid in any way. They buy your goods and they resell them locally. So that's one big difference. And at the end of the relationship, in case it ends, for the distributor, there's nothing that he would ask or seek from your side, because the contract was very clear. It's a distribution contract. The agents, they would have perhaps an indemnization at the end of the activity, depending on certain variables that again must be reviewed and taken into account when drafting the contract. Okay? Ale. Regarding contracts and agreements, and again, this works pretty well not only in Colombia but in any country. And if you can let us give you recommendations about how to deal with potential businesses and distributors and business partners and so on. It's good always to have a legal counsel in the country where you're going to conduct the business. Depending on the type of products that you are going to sell in Colombia and in the other countries, perhaps you would need to address regulatory considerations, regulatory requirements. Normally, products for human beings in Latin America are regulated, thus they would require a prior authorization to in order to export them from Trinidad and sell them locally in Colombia or in the market you're going to go to. Understanding the local market means basically that your business partner, which would be your business partner, would help you to know the whereabouts of the market, how to deal with it, and so on. And perhaps, and depending on each company, you could hire a consultant that would, for example, make a market investigation for you. Again, depending on what is it that you want and what is it, where do you want to go? If you want to come directly, if you want to come via a distributor, if you want to hire people here to act as commercial sales, as salespeople, and so on. There are different ways to come into the market. In order to mitigate the risks, and I want to use these two last items here, again, the most important thing that you need to address here is that you should have clear terms of what you are expecting from your Colombian counterpart and clear terms of what you are going to provide a Colombian counterpart. You don't want to leave the situation where somebody would tell you, I thought that you were going to give me this, and I thought that you were going to do this. That's, again, it's recommendations that would lead to have a smooth operation, and in case something arises, to address it. I saw a question here. Let me see what's the question, if I can answer it right now. Look, if you recall what I said, this is to Jason. Jason, the English version of the contract would need to, in case there is a disagreement or you have to take it into courts, there should be a official translation. So with an official translation, that means that it's a transcript in Spanish for the case of what is said in English. There shouldn't be two different contracts because there's no way of interpretation. What is what's drafted here in English would be translated with a legal and official translator that is appointed by the Colombian government. So there shouldn't be any type of difference. That this agreement would be, for example, at the beginning of the negotiation, but not due to the translation. And in case the disagreement is still on, what stands is the original agreement on the original contract. Again, if it would be the case in the English one, I don't foresee a disagreement due to the translation. And if there's a poor translation or not a well drafted translation, you could ask for a second translation. But nowadays that is not so it could happen, but it would be very, very minimum the occurrence of this situation. Okay. One of the things that we always recommend international companies wishing to do business in Colombia and in Latin America, and aside of signing a contract, aside of reaching an agreement, is to start by protecting trademarks. Be advised that in Colombia, in Latin America, and in most countries of the world, trademarks belong to whom registers them and not to whom uses them. Sometimes we hear situations such as this, that there is a commercial event, an exhibition, and so on. Somebody from any country, not only Colombia, any country is interested in your products, and you would talk to them, and we have a pre-arrangement, and we're happy. They will go back to their country, and they would protect the trademark. In some cases, they do it in good faith. I don't want to say only bad faith, but in other cases, they have the idea that if you're coming to my country, it's with me, not with anybody else. So I'll file the trademark without your permission. Never leave your trademarks unattended. Always, if you have a plan, you want to come into Colombia, you want to go into that X, Y, or Z country, start by protecting your trademarks. Again, and even normally companies nowadays, they have plans. They know they have marketing plans. They know where are you going to be in 2030. If you ask me, let's file the trademarks today because trademarks have processes that could lead into situations that could prevent us of entering the market because there was a background, there was an identical or similar trademark, and there was an opposition, there was an objection, there was something, and that would lead that your commercial project could stop at least for a moment, or maybe definitive. We had an experience with a Spanish cosmetics company. We handled their registration in Colombia, 96 registrations. We were very happy. We told them about the trademarks. Don't worry, that matter has been is taken care by another party, not a problem. They brought the products into the Colombia, the retail put the products on the floor, and the next day they receive a letter from an attorney. The retail company receive a letter from an attorney saying, you're using the trademark of my client, identical trademark for cosmetics as well. Simply the retail company told the cosmetics company, hey, come pick up your things and we're not doing the business. Okay? So you don't want to leave that situation. That's an awful situation for companies that have the means, which is not very expensive at the end, but obviously it costs money. The number one recommendation, even before signing a contract, is to start protecting your trademarks. Then your umbrella, the name of your company, if it is different, if you deal with your company name or of the products you plan to sell. In intellectual property, Colombia follows the rules of the international WIPO, the International Organization of Intellectual Property. We have the same common rules as in Bolivia, Ecuador, and Peru, which gives the opportunity to people who want to file in these countries of the Andean Pact. Starting with one country, you have 6 months to go to the other countries with trademarks. That's the only bargain you have. And the second one would be that if somebody is filing a similar or identical trademark application in one of the other countries, you will have the opportunity to file an objection, but in order to do that, you would need to file your trademark at least 1 minute before in order to comply with the rules. Here in Colombia, we have cases of infringements. You have many activities that, in case needed, because sometimes companies they don't have infringement cases, or you don't have activities related with consumer protection and so on, or unfair competition. But that is something that is well regulated in Colombia in case needed. Again, starting with the fact that you should, as a recommendation, hopefully doing it with us, but no need to do it with us, to protect your intellectual property. Don't leave that for the last activity. Dale. This is a few hints of how it works in Colombia. You can own the registrations, the trademark registrations, and I'm gonna move to say something regarding regulatory affairs. That you can own registrations of products except for cosmetics, but will being located in Trinidad, you don't need to incorporate here. These are the types of trademarks you can file in Colombia. Again, the system is global, except in USA, where use of trademarks gives rights. Perhaps in Trinidad, we filed trademarks in Trinidad, but I am not quite sure how the system is the same, the classification is the same. Normally, you would have the same types of trademarks and so on. And there's a classification from class 1 to 34 are products, from class 35 to 45 are services. This is the next one. This is the registration process in Colombia. All applications are published. You see the fourth item, that's the publication. The publication is the option, the way that Colombian government tells everybody, somebody from Trinidad is filing a trademark. If somebody feels that has any rights to oppose, you may oppose. If there's an opposition, somebody would that the Colombian PTO would notify the agent, and the agent has a 30-day period to respond to the opposition. And at the end of that period, the Colombian PTO, Patent and Trademark Office, would make a decision. The decision could be to accept the arguments of the party that is making the opposition or not to accept them, and to either deny or grant the trademark. Whomever loses have the opportunity to file an appeal, and once the appeal is decided, and depending on the decision, whomever loses can go to the higher court, okay? In that, from day one, which is a submission for us, until the final decision with no opposition, it can take 6 months to have the process covered. With an opposition and with the appeal, it can take up to 15 months. But the most important thing here to bear in mind is that this is a first come, first served basis. That means that you would need to go to the line, make the submission. That means that your submission will be processed. And if somebody, for example, makes a second submission for the same or identical or similar brand, it will be addressed in a second after finishing your process. That is why it's very important for you to start trademark procedures if you're planning to come into Colombia or, again, any country of the region. Now we're going to start, and Isabel is going to jump in, and I'm going to help her with regulatory affairs. But I can start here. For human beings, most of the products that we use are regulated. There are a few exceptions in the case of food and beverages. If you sell the products to the Horeca, hotel, restaurants, and cafeterias and casinos, and your products are processed foods, they don't need registration. But if those same products, you're going to sell them on a supermarket chain, the same products, they would require of a permit. So go ahead, Isa.
Isabel, I think you are on mute.
Oh, yes, sure. Thank you. Okay, hello. Thank you, Alvaro. And we are starting with our government agency, which is INVIMA, which is the Institution of Control and Vigilance of Foods and Drugs. This is the translation of the name. And we have specific laws basically for each type of products that needs a registration or that needs control by the authorities, and some alliances that we can use when you are going to distribute products in Colombia and other countries. For example, in this webinar, we are going to talk about foods, cosmetics, and home products. And in this case, specifically, we have an alliance with the Andean community. That means that the regulation is the same for Colombia, Ecuador, Peru, and Bolivia. Unfortunately, the process is not exactly the same because each agency takes their own internal rules and concepts and specifications, but most of the process and requirements at least are the same. Sorry, here. The conditions to register a product in Colombia are most of the conditions are written here in this slide. And we can normally, as Alvaro told you, you can be the owner of your permit, except for cosmetics, which started working like 1 or 2 years ago when the regulation changed. So only for cosmetics, the owner must be a local company. For other products, you can be the owner of the permit, even if you don't have a company here in Colombia.
And for that case, let me jump in. And for that case, we recommend that you use a hosting service such as the one that we carry, but other companies might provide the same service, because you don't want to leave the situation that your local distributor owns the health permits of cosmetics, and perhaps the commercial relationship doesn't bloom, and you decide you want to move along, and they own the registrations. So again, as an advice, you don't have to do it with us. You may do it with your distributor. You may open a company in Colombia, and you may use a hosting service such as the one that we have, but other people could also do it, because you don't want to be, you want to control, your commercial, your business. You don't want anybody to be on top of you. That's one recommendation that we have.
This is very important, and it's normally if you have an owner and you want to change it, you can transfer the permit. And that's the first thing that many of the persons think. But when you change the good relation with a distributor or an importer, sometimes these transferences are very hard, because they don't agree and you will have a not good time. So this is why we always advise that if you can be the holder of your permits, do it, even if it's necessary to use a hosting service for cosmetics. You can add multiple importers. Here in Colombia, only the importers are included in the permits, not the distributors, so only the importers. And depending on the product, they must be authorized by the authorities to do something. For example, for cosmetics, if your importer is going to take care of the conditioning, the labeling, it must have a certification to do it. So you must check what it's going to do your importer, and if it's needed to have a previous authorization from the authority. We can register families, groups, or several varieties of any product in the registration. Of course, depending on the characteristics of these products, they must have a common characteristics, composition, and we will talk about it later. Brands can also include several brands and several manufacturers of the same product in the registration. These are some general conditions that must be considered when you are going to start a registration process. It's to register or appoint a local company if needed. If you need a local company as owner, register this company before the authorities if needed also. Start with a check of the ingredients and the formula of the products to see if the ingredients are approved, even the ingredient or the concentration of each ingredient. Prepare a technical and legal dossier to be submitted. Then we will prepare it and submit the application. Wait for the answer of the authority, which in the 3 cases that we are talking today, it's an automatic process. We will talk about in the next slide. And then you can start to import and commercialize the product. Here is a summary of the registration process. In Colombia, there are 2 types of processes, automatic and non-automatic. The difference is here that we will receive in the automatic process, we will receive first the registration, the certificate, and in case the authority has questions or needs additional information, they will make a further review and they will make an office action to ask for the complementary information. In this case, you can start importing or exporting, in this case, the product once you receive the registration, being sure that if you receive an office action, you must answer on time, because if not, the permit will be suspended. For the non-automatic process, it works in the other side. So you will first receive the evaluation, and in case needed, the office action, and then the registration will be confirmed. These are the main requirements that we will require for a registration of a process: power of attorney to, in this case, our office or anybody that which will be taking care of the process. It must be legalized or apostilled. You must appoint an importer, at least one, because in all the cases except for cosmetics, you must appoint an importer from the beginning. At least one must be included in the registration. We will need a letter of authorization to this importer, which authorizes them to commercialize and distribute the products in Colombia. A free sale certificate, normally, except for cosmetics, which Colombia accepted the option of not needing a free sale certificate for cosmetics registration. Technical information, which varies depending on the product, but basically it's to confirm the composition, the characteristics of the products, and in case that they have claims or any special indications, everything must be supported with studies or studies. Go ahead.
Yeah. To be sure that everybody's on the same line and that Isabel can drink a bit of water, POA stands for power of attorney. LOA stands for letter of authorization. FSC stands for free sale certificate. Just so she could drink a bit of water.
Thank you. Part of the information that we have to supply is the artwork of the labels, and that labels must comply with some regulations specific for each product, which we will see later. And as I was telling you, every claim must have a support. It can be a laboratory test or a clinical study or sometimes validation of the studies, but every claim must have a support. Here is the timeline expected. Normally, these timelines that are here in this slide, as the three types of processes are automatic, takes around 20 to 30 days. It can change depending on some situations in the authority, but normally it takes no longer than 1 month.
But here, automatic in Colombia, it's not. I imagine automatic in Trinidad would be that you send and it comes out. Here, automatic takes from 20 to 30 days.
Yeah, and the validity of each permit depends on the product. For example, for foods, there are 3 types of registrations, which I will explain you in a while, and the duration of the permit depends on the risk of the permit, so 5, 7, or 10 years. For cosmetics and home care products, as they are from part of the Andean community, it by regulation states that it's 7 years. Together with the request of a health permit, there are some associated processes that you must consider. And there are modifications, renewals, cancellations, suspensions, and appeals that can happen in any time during the validity of the permits. And specifically for modifications, you must note that the owner of the permit is responsible to maintain updated the files. So if you make any change in the formulation, in the package, in the manufacturer, in the manufacturing process, or any change you make, you must notify distributors, importers, correct? You must notify the authority, and all these notifications must wait for an approval of the authority to start doing the change. These are the type of modifications that you can make from the legal aspects. Standpoint, brands, holder, manufacturer, importers, commercial presentations, and these are the technical modifications. Normally, all of these must be sure that the original nature of the product is not changing. For example, if you have a cosmetic, which is a cream, and you are going to change it to a gel because the composition will change, the modification won't be allowed and you will have to make a new permit. If there's a food and you have a tuna fish and you want to add for sardines, I don't, thank you. You cannot include this in the product. You must obtain a new permit because tuna and sardines are different products. So this is what I was telling you about food classification. There are 3 risks: high risk, medium, and low risk. The risk depends or was defined because of the risk on the common population, the risk that the food can produce illness or infections in most of the population. So the products in high risk are all those that has the main ingredient is from animal origin, all those foods that are fortified or enriched, those products that has water as main ingredient, and salt. Medium risk, for example, canned fruits and vegetables, pasta, vegetable oils, and flour. And the low risk, for example, spices and aromatic herbs, breakfast cereal, bakery, nuts, and oat. So the first thing when you have the product is to classify them. Then you can see which type of permit you will receive. And depending on this, you will see if there is high risk, your permit will be valid for 5 years, medium risk 7 years, and 10 years if there is low risk.
But we will help you to classify it, no, in case needed. That's part of our activity.
Yes, and that's the first part that we must do, because depending on the risk, there are also the fees associated to be paid to the authority. Also, our authority has some ranges. So you can include in foods, there are ranges to pay the official taxes depending on the quantity of flavors, for example, that you are going to include in one permit. So we will inform you this. This is we have a general law for labeling, and what this law establishes is the main information that must be in a label. A general labeling for the products. Normally, the packet food, which is those that directly goes to the consumer, needs all this normal information. Some of the information for raw material and fractional food, but raw material doesn't require a health permit, as Alberto told you at the beginning, but you must consider the labeling. From 2021, we have new regulations regarding the nutritional labeling.
Let me say something to the prior, this one. So one question that you could imagine to ask is, okay, do I need to make a label for Colombia with this, what is required for packed foods? The answer is no. You can use your label from the origin. You would need to have certain information added, either the label coming from Trinidad or via a sticker that can be added in Trinidad or even in Colombia. And that is basically the information that is mandatory for example, the name of the manufacturer and domicile. We would say fabricado por in Spanish, manufactured by.
The health permit, for example.
The health permit that we don't know at this moment because we haven't made the submission. And for example, if your label states expiration date, it should be in Spanish fecha de vencimiento, and simply the translation into Spanish, because you can put, for example, an expiration date with a V, which is vencimiento, and the date on the side, and so on. But that is something that is going to be addressed at the proper moment. But the idea of what I'm saying is that you don't need to make a label for Colombia. You can use your local label, but you have to bear in mind that certain information must go in Spanish, either directly from Trinidad or via sticker that can be added in the facility or here by the distributor.
About this complementary label, it's very important to tell you that with this complementary label, you can put complementary information, this information that it's only mandatory in Colombia, and of course it's not in Trinidad and Tobago, but you cannot correct information. So if, for example, you have a list of ingredients from the origin, and the product for Colombia will have a different list of ingredients, this list of ingredients cannot be corrected via this complementary label. In this case, you must make a specific label for Colombia. So no corrections are allowed with the complementary label. Okay, so talking about nutritional labeling, it started, we had a nutritional regulation many years ago, but in 2021, it has many changes, and then in 2022, another time it changed. Basically, what it was included, it's a frontal warning labeling, which must be in the upper part of the front face or of the product, and it must include, or it must report, excess of sodium, sugars, saturated fats, and fat trans, and sweeteners. Here I have like an example of one packaging, which has the main requirements as the first slide we see, the brand, the nutrients, or the ingredients, the information that it's mandatory. And if, for example, you need to add the seals, it must be here in the front of the package in the upper right side. You have to include some specific issues in the nutritional chart. It has some designs in the law, and there are some mandatory nutrients that you must include. This nutritional chart, for example, can be changed via the complementary label that Alvaro was talking. Normally the nutritional facts in every country, the nutritional chart, it's different. It has different parts or nutrients that are mandatory. So this chart can be added here via stickers. So that's like an example of the information. Something that is very important is that if your product has a seal, any of the seals that we see here, if your product needs one of these seals, you cannot include any claim for the product. For example, you cannot say that it has sweeteners, but it's low fat. If it has a seal, you cannot claim anything for the food. And to define if your product needs a seal, normally what we do is to have a check of the product nutrients via laboratory analysis, or sometimes we can use known charts like FDA or for the products. Okay. Now for cosmetics, we have a definition here, which is the same definition that is used in the Andean community, as I told you previously, and there are products that can be locally applied for the parts of the human body in these parts: epidermis, hair, nails, external genital organs, teeth, oral mucous membranes. And the intended use must be this one: to modify their appearance, to protect them and prevent or make it smell better, but it cannot have a treatments or any claims that are therapeutic. These are the types of cosmetics. Here, our classification depends on the area that must be that they are going to be applied. So for skin, for lipsticks, for the lips, for the nails, deodorants, toothpastes, eyes, and the common characteristic is that cannot have therapeutic effects. And in these cases, there is like an international classification which is known as cosmeceutical. But here in Colombia, we don't have this differentiation, and it has been sometimes difficult to classify this type of products, because normally the authority says that these types of cosmetics that has some therapeutic activity must be classified as medicines. Sometimes, for example, the products that are intended for acne, we cannot say this word in our regulation. So if you put the word, it will be classified as a medicine. Sometimes what we do with our clients, of course, is that they change the word and the indication it's slightly different. Like you can say that it's to cover black points or pimples, but it's not specifically for an illness, because in this case, the product will be classified as a medicine. Here are some forms of the cosmetics. I was telling you that, for example, these are very important because you must state this in the registration. And if it is, for example, a cream and then you are going to change to a gel, then there is a different product.
A different registration.
Yes, sure. Yes, excuse me. A different registration. Okay, for domestic hygiene, which are the home care products, there's also a regulation which is used in the Andean community. And there are some specific types of products. Not all the products that we use for cleaning are included in this regulation. These are basically these products, and normally they are intended only for use in home. If they have industrial use, they won't require this type of registration. This is only for home care products. The notification, which is called the permit that we obtain for this type of products, will be for 7 years too.
Isa, one question to Vincent. How are we on time, or should we speed up?
You're doing well. You're doing well.
Okay,
you can continue.
Okay, perfect.
Okay. We are almost done. We are only 8 slides to finish. Okay, so in general, for cosmetics and home care products, we can group the products in one registration. Because normally when, for example, companies with cosmetics has big lists of SKUs, and you obviously don't want to have 1,000 permits. So
we yes,
yes,
know.
but you don't. So in this case, we can check the products, and if they fulfill with these requirements that you are seeing here, we can group several of them in one registration. For example, to group one, the basic qualitative and quantitative composition must be the same. Normally, what changes is the color or the aroma, and but the main ingredients and the active ingredients must be the same. In perfumes, the perfumes cannot be grouped because the main ingredient of a perfume is the aroma. But for example, for splashes and lotions that has main ingredients, other products like agua, water, for example, you can group them because the aroma, it's a little part of the formula, and it's in these cases you can group them. Not for perfumes, but yes, for splashes, for example. In the same case for home care products, which are fresheners, air fresheners, we can group them if they only has a variation in the aroma. Dyes with the same qualitative composition of the colorants, but obviously a different color, can be grouped, and makeup cosmetics with the same basic composition and different shades. Here is like a summary also of the labeling conditions of the cosmetics, and this applies also to home care products. This is the main information that you have to include. You can see also that you must include some specific information for Colombia, and in this case, the same condition for the complementary labels applies, being sure that you are not going to correct information just to complement the information that it's on the package. This is very important, for example, for the claims that you are putting that you are including from origin in the packages. But for example, in the case of acne, if you have a claim that it's specific for acne, you cannot cover the claim with a white label, because you are correcting information. Just you can use the complementary labels to complete or to complement the information that it's from origin in the package. Here are for other regulatory activities that can be done for all type of products, and that you must consider all those local authorizations. For example, the licenses that must be held by the importers in case they, for example, needs to add these complementary labels. They must have certificate of sanitary conditions for cosmetics or for the home care products to do it. Also, they must have a technical director, which must be a pharmacist with a card, tarjeta profesional,
Okay.
in Colombia. Authorizations refers to labels or packaging material authorizations. For example, if you make a change in the packages and you report it to the authority as it is mandatory, you can ask for a labels exhaustion, so your packagings that are already in the market or in your warehouse can be used, and you don't have to destroy them. Normally, these authorizations are accepted by INVIMA in some specific occasions. That, for example, if a permit is suspended because a risk to the population, and this risk involves a change on the labeling, normally these authorizations are not given by INVIMA because they tell that the label it's include this risk situation. So in these cases, we must check if this is allowed or not. We have certifications, like for example, in some cases we can ask for a certification just to confirm that a specific product doesn't require a permit. It most of the times occurs, for example, for raw materials or for products that are not, for foods that are going to be used only in restaurants or as raw materials. Some manufacturers and importers decides to ask for a certification of non-obligatoriness of permit because to avoid inconveniences in the port, because sometimes the people in the port has different interpretations of the law and can ask for permits when it's not required. So sometimes the companies decide to have these in order to be secure and not to having problems in the port. Regarding post-marketing activities for these three types of products, cosmetics, home care, and food products, it is not mandatory to report, for example, adverse events or situations with the products, but it's highly recommended. There's no a specific program as for medical devices and medicines, which are very well established programs, but it's highly recommended that if you, for example, found that one of your products has a risk, make a report to the authority and take the product out from the market. And regarding advertising, these three products can put in the marketing advertising many information. Most of this information must be the same as reported in the registry or in the permit, so it has a like they are the same. Yes, it is not mandatory to ask for a previous authorization from the authority for this advertising, but it must fulfill with all the requirements. So it's highly recommended also to review the advertising before you put it in the market. Alvaro, go ahead, please.
Okay, this snake shows everybody how it should go. These are the tips that we provide our clients to have a well efficient regulatory process, and you can look at it from any you can start in any place. At the end, the idea here is that all of the documents that you are going to provide for the submission are equal. If your manufacturing site is called A, all of the documents should be A, and so on. Sometimes we find that our client sends information regarding a facility, but the technical information comes out from another facility, and that leads to inconveniences with the submissions. We strongly recommend our clients that you can add all of the information from the beginning. That means that by doing that, you won't need to make further modifications except when needed. If you have, maybe the market today is only asking for, to give an idea, for 100 products that are in 100 grams presentations, but you also carry 200 and 500 and 1,000 and whatever, include them all. If you include them all today, you won't need to make a modification down the road, okay? If, for example, you use a third party as your manufacturer, we would need to show that's the situation, and that situation is shown easily with a manufacturing contract or agreement and so on. And again, if you see all of the documents that we must submit to the authorities have to be clear so we can have a swift process. I don't want to continue with because it's very clear, and you're going to receive this a presentation. But this is what you need to always bear in mind to have a swift regulatory process, and at the end, a business process. Ali.
Here are like some approximate fees that you must pay for each registration process, and in these three groups. These are referred only to official expenses that must be paid to the authority. In the case of cosmetics, it's something that I forgot to explain you at the beginning, is that now, as you know, the owner of the permit of a cosmetic registration must be a local company. As per our recommendation, we don't recommend that the importer is the holder, because then you can have problems. So if the owner is one company, you must add the importer in a second step. You can add as much as you want. All the importers that you want can be added. So that's why there are two fees. The first one is for the registration, and the second one is to add the importer, which is called parallel importer, and can be added any quantity that you need.
And these are the general. Sorry.
Go ahead. Go ahead.
No. This is a summary of what we have told you because this is basically the end of the presentation. Here are recommendations. These recommendations, as you can see, are not too complicated to address, but if you address them in due time and priorly to sign agreements and to move into the market and so on, you would have a healthy business in Colombia, because you won't be like you won't have issues that would make you change your focus, which should be to do business in our country. So these are the recommendations. Again, we strongly recommend to protect your trademarks. Dale. And that's it. Let's work together to make opportunities happen. We want to thank again Vincent. We want to thank all of the audience for being here and for staying with us. Again, if you have questions, please go ahead. Belkis, we're waiting for your reply if you're still here.
All right. So thank you, Alvaro and Isabel, for that presentation. There was a lot of information, but it was a lot of excellent information, which I think is very important for all of us to know, to better understand doing business in Colombia. So please, guys, we have the experts in the room right now. So please use the chat bar and ask as many questions as you can while we are going on to our next presenter. So please use the opportunity to capitalize on the knowledge that we have of our two presenters. So our final presenter for this morning's session is Mr. Krishnan Maharaj. He's the Manager of Capacity Building and Funding at the Trinidad and Tobago Trade and Investment Promotion Agency. Krishnan will share with us some of the funding mechanisms that are available to exporters who are interested in doing business in Colombia. So Krishnan, over to you.
Thank you, Vincent. Good morning, all, and thank you to Isabel and Alvaro for that very thorough presentation. So what I will present on is ways that the agency could support companies who want to get into Colombia based on some of the things that our previous presenters spoke about. So let me just get this presentation up and running. Right, Vincent, do you see it, ma?
Yes, we're seeing
Yeah.
your presentation.
Nice. All right. So once again, I represent the Trinidad and Tobago Trade and Investment Promotion Agency, the export arm of it, which was formerly Export TT. And what I want to get straight into is co-financing. So co-financing is financial support to help companies offset certain export-related activities. So it's funding, it's counterpart funding. It's not like a loan or anything, it is grant funding that is available. So this would, help companies to free up more of your resources by offsetting certain export-related costs, because a lot of issues that have to be made right before entering Colombia were highlighted by Isabel and Alvaro. And we can assist through this co-financing service with two things specifically that I can think about. So there's the product registration in overseas markets. Now, from what was said, it might not be necessary for company or product registration in overseas markets. However, you might have some buyers or distributors who might ask for that to be done. Equally as important, or probably more important, would be the intellectual property registration in overseas markets. Now, we heard about the support that is available for trademark registration, patent registration, however, whatever forms of intellectual property that you're using to protect that intellectual property that you have in the markets, there is support under the co-financing service to offset some of the costs that would be incurred there, because you will need legal support in getting these things done. And it is advisable that you get legal support on the ground in the market that you are working on. And we had two experts with us in the room today. There's support for the translation and interpretation of export-related documents. Now, it was said that the agreements do not need to be in English. However, in the case of arbitration, or if it has to be taken to court, there has to be one common document. If that is required in Spanish, which I assume it will be, there is support under co-financing for that. And then there's other export-related documents that Isabel had highlighted that may need to be in Spanish, and proper Spanish, not Google Translate Spanish. So there's support for the interpretation and translation of those documents as well. All right, another thing that was highlighted this morning was the labeling and product requirements for entry. We heard a lot about what's required for cosmetics and for food and beverage products. There would be other products and different requirements as well. So there is support under co-financing for the costs that would go into making sure that you meet these requirements, and labeling modification. So there's support for labeling, for product modification if required for the market, and testing, because there are the mandatory requirements for your product to sit on shelves in Colombia. So there's support there under co-financing. We also assist with shipping of samples to prospective buyers in overseas markets, in this case, Colombia, because your buyers, your distributors might want to have the product in hand to get a better understanding of what it is that you are attempting to sell, or want to get an idea of what the product looks like shelf ready. So there's support there. There's support for e-commerce functionality, because as you go into international markets and you find your buyers to do your in-store sales, you may also want to sell B2C to international clients, but your website doesn't allow for that to take place as yet. There is support under co-financing for e-commerce functionality that would assist you to have your site ready to accept those international B2C sales. And there is support, again, under co-financing for in-market promotion. This is for when you have your buyer or your distributor on the ground in Colombia. There's support there to promote your product in market. So these are just a couple of things to bear in mind, and the kind of support that is available from the agency to assist with some of these requirements to enter Colombia. And there is support there for you to engage with the proper experts, such as SBI, to get this sort of work done. So how it works with co-financing is that co-financing will offset up to 50% of the cost related to market entry activities. Now, there are different limits based on your company size. For small companies can access up to a total of 50,000 TT. So it's 50% of the cost to a limit of 50,000 TT. How it works for the small companies is that if you are approved when you apply, you pay your 50% to your provider, and the agency will pay the other 50%. So that's not reimbursable for small companies. For medium-sized companies, and the service is available to small and medium-sized companies. For medium-sized companies, you all can access up to a limit, so 50% to a limit of 25,000 for these activities that are covered under co-financing. In the case of medium companies, it's reimbursed. So you pay a full amount, and then the 50% reimbursement is done, reimbursed to you, to your company. Bear in mind, though, this is not reimbursement after the fact. If you know you're going to engage in these activities, please send in your application before, so it's pre-approved. And then we will evaluate it, make sure you are approved, and draft a contract accordingly to either reimburse the 50% or pay the 50% to your supplier. There's one other thing I'll touch on. I know we're getting close to lunchtime here in Trinidad. So one last thing I'll touch on is the International Certification Fund. This is designed to meet certification that is required for entry into export markets, such as Colombia. Now, yes, it will assist with mandatory requirements, which is essential depending on your the nature of your product. But there's also assistance to meet the certifications to comply with the buyer's demands or the buyer's specification. So if there is a particular certification that has been met to enter the Colombian market, to sell to a particular distributor and is identified to you, you could also consider applying for the International Certification Fund, the ICF, for assistance there. So the ICF covers the certification cost itself, because there's the audit cost, and then there's a separate certification cost so that you can have that certification that you could put as a stamp on your packaging and your marketing. So it supports with the actual cost of getting certification done, as well as building the capacity and the conduct of the audits, which is the first step. The acquisition of specialized equipment required for the adoption of standards. Bear in mind, this means equipment that is necessary to meet the standard, not the production equipment. There is another grant for production equipment that SMEs can apply for, but under the ICF, we're talking about equipment that is required to meet particular standards. For example, maybe like a industrial X-ray or like some sort of metal detector or something that's required to meet a particular certification, such as ISO or FSSC 22000. There's infrastructural modification to comply with standards as covered as well. Now, this does not mean building a new facility, although I'm sure we'd all like that. It is actually for modification to comply with the standards implementation. as instructed by a consultant or an expert as part of building the capacity and gearing up for audit. Costs are covered as well, include the auditing costs. So how this works is that is tiered. What you can access is tiered based on how much you export. So it's not necessarily company size, but how you export. So for companies who export under 1 million US, you can apply for 100%, sorry, of the cost to a limit of 500,000, right? But these are costs specific to getting that certification. This for if you are exporting. Now, there might be a scenario where you are producing to displace imported products that are coming in, that you engage in import substitution, which is another way to keep, Forex from leaving the country. In that case, we are looking at companies who who sell less than 25 million TT could access that fund for the purpose of import substitution once you could give a proper justification that you are, in fact, assisting with import substitution. So there's that as well to consider. And this is for the international certification. International certifications are extremely important for entering international markets, especially in Latin American markets where there are large, sophisticated markets with set criteria and requirements to protect the safety of the consumer is necessary to get your certifications in place. And I think that would be it. Yeah, that's just what I wanted to touch on this morning, because those are the two areas that I think the agency could lend support to assist with your drive towards exporting to Colombia. So thank you very much, and I look forward to the questions.
Thank you, Christian, for that information and for sharing information on the funds and the grants that are available to Trinidad and Tobago companies. So I just took a quick look at the chat bar and there are no questions. So I don't know if that means all of our presenters were extremely 100% clear.
Are you hearing me?
Yeah.
Yes, we
Yeah.
are now.
Hi, good morning. My question is are there any in terms of exporting, is there a market current for items in the oil field industry in Colombia?
So is that the question is
For
for us or?
example, wire rod coils, and other items, small items in the industry? Is there a market for exporting that to Colombia?
Rachel, I think that's a question that I'll probably take. I think you can reach out to me and we can take a look and do some analysis, and we can even work with the agency to provide you with some market research to see if these items are being imported into Colombia and what are the volumes, to see if there's opportunity for your company.
Yeah. Okay, no problem. I'll get on to you, Mr. Ramlochan, and we could probably set up a meeting if possible. Thank you for your time.
No problem. So I think we have another question from O'Shea. I hope I'm pronouncing your name correctly.
Good morning, everyone. Yes, you are. My question is concerning intangible products like animation and broadcasting. Is there an avenue where the grants would apply, or even a market in Colombia for such a product?
Son.
All right, O'Shea. So in terms of the grants, they're not the grants that I presented on. Now, under the co-financing, there is support. So you can get support for your securing intellectual property. I'm not sure how it's done for the delivery of digital services, if it is to prove copyright or if you could patent code and content, but there is support there in terms of securing intellectual property. There is also another grant called the grant fund facility that could assist with the acquisition of, to his phrase, to say production equipment, but for the ICT enabled industries and the creative industry, there is support there for equipment and software to improve your production capacity.
But what,
And of course,
sorry.
no, sorry, go ahead.
I said, so what are the requirements to do so? I mean, do you have to, I mean, I know you talk about small companies, large companies, but
Right.
they have a requirements to do so?
So for the grant fund facility is small to medium sized companies. You need to have financials. They ask for audited financials. However, if you have solid management accounts for like a 2-year period to show your financial performance, that'll be fine. Your company has to be a going concern for 2 years, meaning that you have been registered and generating revenue from your core business for 2 years. And that essentially is like the base requirements to apply for that particular grant. Now, my contact info is in the chat, so you can feel free to give me a call after. And we can run
Okay,
it
no
through.
problem. Thank you.
Thank you,
All right.
Christian. So I'm just taking a look at the chat bar. I see there's a question from Lisa. Do we have information or data on food products that will do well in the Colombian market? Lisa, you can please reach out to me, and we can also put you on to someone at the agency who can be able to provide you with import data in the Colombian market that can be able to assist you. So Faith was asking for Christian's contact, which he would have already put into the chat bar. All natural salad dressing be viable export, a product to export. So again, these are questions that we can assist you with, Lisa, to just be able to give you some information to see what is the potential in Colombia. So there are persons in the research team at the agency, and as well I can support with that information as well. So let me just go through as well. So Rachel was asking, can you estimate in terms the number of retail outlets in Colombia? So all of these are like a lot of research questions, and we can be able to provide that sort of information for you guys. Or I don't know, Isabel, Alvaro, if they have any last thoughts that you would like to share with our participants.
Oh, happy to receive all of the products that you can bring down to Colombia. Our market is a dynamic market. We're 52 million, more or less, inhabitants. Where the economy is in good shape. For who was asking, Rachel, the retail here has shifted. We now have very important players of hard discount, very important players, and we have organized a retail chains. Recently, this year, the main one was purchased by a group from El Salvador, El Grupo Calleja, and it's called Éxito, which has many formats and many brands and so on. But Vincent and this market intelligence, I'm sure that Vincent in the embassy and the agency can provide information. Thank you very much. We're very happy to be here. Always we're open to hear from you guys. If you have questions and so on, happy to assist. And looking forward to hear from you.
All right, so thank you guys again. So I would just like to formally thank our presenters for their willingness to share their knowledge and their expertise with us this morning to help us better understand these key concepts when looking at doing business in Colombia. I as well look forward to supporting each and every one of you through your exporting journey to Colombia and other Latin American markets.